Hi guys, it's Kathy. I hope you're doing well. Yes, Josh, it's hump day. Yes, yes. Wednesday. We're going back to Hell Court today, but remember she changed courtrooms. So it's not Hell Court anymore. But I don't know how else to describe her now because that's how we've been describing her for years. I always forget her name at first, but then I do remember it. It's not Teresa. It is Teresa, but it's not Capaldo. I don't think they show it, do they? No. It'll come to me. I promise. Here we go.
Battery as a Class A misdemeanor, and that would be in CM 1027. You're also going to plead guilty to possession of marijuana as a Class A misdemeanor in CM 989, and you are going to admit that you violated your placement on probation in CM 968. Is that correct?
Correct.
Sir, the terms of your plea agreement indicate that for the charge of possession of marijuana, you will be sentenced to 180 days at the jail. However, that will be served on alternative placement on Elkhart County Community Corrections, it looks like.
Yes, ma'am.
The level of your supervision will be determined by Elkhart County Community Corrections. You will have to obtain addictions evaluation plus any recommended follow-up treatment. And you will pay the mandatory court costs, which includes the $200 drug interdiction fee. And you'll receive credit for 2 days served at the jail. For the domestic battery charge, you will be sentenced to 1 year at the jail. That will be suspended on probation at a level of supervision deemed appropriate by the probation department. You will pay the mandatory court costs, which includes the $50 domestic violence fee. And all of the other terms are left at the court's discretion. These sentences will have to be served consecutively to each other, meaning one after the other. Do you understand that?
Yes, ma'am.
For the probation violation, there is a recommendation that you be dishonorably discharged from probation and that you receive credit for 30 days at the jail. Is that correct?
Yes, ma'am.
But Mr. Perkins, I will explain in just a few moments the difference between the recommendation on the violation of
He's time served.
time served. Okay. Never mind. So your time served on that violation, correct?
Correct.
Okay, so then talking about community corrections, through Elkhart County Community Corrections, that can be either work release, electronic monitoring, or daily reporting, or it can be a combination of those levels of supervision. Do you have any questions about what that means?
No, ma'am.
For probation, that can be either reporting or non-reporting, or a combination of those two levels of supervision. Do you understand that?
Yes, ma'am.
Mr. Perkins, it is possible that you may have to complete additional programming or treatment in addition to the addictions evaluation possibility. That can include domestic violence programming, parenting programming, or mental health treatment, or anything like that. Do you understand that?
Yes, ma'am.
So it is also possible that the court can order that you have no contact with the victim of the domestic battery charge. I can also order that you pay the victim restitution if the victim suffered a financial loss. I don't know anything about the fact pattern right now. I'm just telling you generally the terms that the court can impose. Do you have any questions about that?
No, ma'am.
Mr. Perkins, in looking further through the written plea agreement, I see that there are initials that appear in the numbered paragraphs in the defendant's right section. There is also a signature at the end of the plea agreement. Are those your initials and is that your signature?
Yes, ma'am.
Just a minute here. I just need to get around my. Mr. Perkins, before you initialed those paragraphs and signed that document, did you read through it carefully?
Yes, ma'am.
Did you also review the plea agreement, Ms. Schweinsker?
Yes, ma'am.
Did you understand the plea agreement?
Yes.
And do you understand the rights in the defendant's right section?
Yes.
Mr. Perkins, do you understand that when you plead guilty that you give up your right to have a trial by jury?
Yes.
Do you understand that by pleading guilty that you are giving up your right to remain silent?
Yes.
Do you understand that by pleading guilty that you are giving up your right to confront anybody who's accusing you of these offenses?
Yes.
And do you understand that by pleading guilty that you are waiving or giving up all of the other rights during the advising of rights section of your plea agreement?
Yes, ma'am.
So before you appeared in court this morning, did you consume any alcohol, drugs, or medications?
No.
Do you believe that you are thinking clearly today and that you understand these proceedings so far?
Yes.
Mr. Perkins, according to your plea agreement, you are a citizen of the United States. Is that correct?
Yes, ma'am.
Sir, has anybody forced or threatened you into pleading guilty?
No.
Are you pleading guilty today because it is your choice to do so?
Yes, ma'am.
Has anybody promised you anything to get you to plead guilty other than what is in the plea agreement?
No.
Do you understand that if I accept your plea agreement, that I will sentence you according to the terms of the plea agreement?
Yes, ma'am.
Do you understand that your plea of guilty may cause harsher sentences for any crimes that you might commit in the future?
Yes, ma'am.
And again, sir, you are pleading guilty today to possession of marijuana and domestic battery, both of which are Class A misdemeanors. A Class A misdemeanor is punishable by up to 1 year of incarceration and a maximum fine of $5,000. The crime of domestic battery is also a crime of domestic violence. And what that means is at the time of your sentencing, I will make a domestic violence determination. And that means that you will be prohibited from possessing firearms and ammunition. It means that you may also have restrictions in parenting time with minor children. Do you understand that?
Yes, ma'am.
Sir, have you reviewed these charges with Ms. Schweinsker?
Yes.
Did she explain to you that, or the possible penalties and what the state would have to prove in order to convict you?
Yes.
Ms. Schweinsker, does your client waive the formal reading of the charging information and statutes?
He does, Your Honor.
Mr. Perkins, do you understand what the state would have to prove that you committed these offenses?
Yes.
And do you also understand the possible penalties that you face?
Yes.
Mr. Perkins, do you understand that one of the terms and conditions of your placement on probation is that you cannot commit any new criminal offenses?
Yes.
Do you understand that?
Yes.
Do you understand that by pleading guilty to crimes that occurred while you were under the supervision of probation means that you are also admitting that you violated your placement on probation?
Yes, ma'am.
And with everything that we've discussed today, do you still want to plead guilty pursuant to your plea agreement and also admit that you violated your placement on probation?
Yes, ma'am.
Thank you. Factual basis, please.
Thank you. Joshua, let's start with the domestic battery case. Look back to September 4th of 2022. On that date, were you in Elkhart County, state of Indiana?
Yes, ma'am.
And you were in a relationship with Denise Haggerty at that time, is that correct?
Yes, ma'am.
You're still in a relationship with her?
Yes.
The two of you have children together, is that correct?
Yes.
Do you admit that at that time you touched her in a rude or angry manner?
Yes.
And you're guilty of domestic battery, correct?
Yes, ma'am.
Turning your attention next to May 10th of this year, you admit that on that day you were found in possession of marijuana.
Yes, ma'am.
You knew there was marijuana, you had no medical or legal reason to be in possession of marijuana, is that correct?
Correct.
And you had a prior conviction for possession of, an offense involving drugs out of Elkhart Superior Court number 3 from June 25th of 2018, is that correct?
Yes, ma'am.
Thank you. And then also you were placed under probation supervision in July of 2019, is that correct?
Yes, ma'am.
And you admit that it's a violation of the terms of your probation to have not obtained a substance abuse evaluation that you were ordered to do?
Correct.
And you didn't complete your community service hours on time, is that correct?
Correct.
And you were also charged with the new offense of possession of marijuana that you just pled guilty to, is that correct?
Correct.
You admit that those are violations of the terms of your probation that you were placed under at the time?
Yes.
Nothing further on a factual basis.
Mr. Leal.
No questions based on that.
The court will find that the defendant has tendered a knowing voluntary plea and admission. Counsel, do we need to set these matters out for victim notification?
Judge, she's here today, if we could
I think we
proceed.
had anticipated doing notification, but the victim is present. I think we can go ahead. If the court's
The
comfortable.
parties are comfortable, the court is comfortable. Arguments, Ms. Schweinsker.
Thank you, Your Honor. Joshua's been very cooperative during this process, and when we spoke, Denise was there as well, and they are a family unit. Everything's going well with them. They have children together. They're engaged. They're looking to get a house. Josh is working full time. They just got a new vehicle. Everything's going well for them. And I think the problem that was causing everything to kind of fall apart is that Joshua was having some substance abuse problems in the past. That was causing relationship problems in the past. That was causing most of their problems in the past. He talked a lot about the fact that he is clean and that that's no longer an issue for him, and it's caused much healthier relationship between he and Denise. So I'm hopeful that that will continue and that he will be able to get through his community correction sentence and his probationary term. The probation case, it looks originally as if it was a 1-year sentence. However, when you look closer, it was an error on that sentence. It was actually a 60-day sentence out of Superior 3. And he was time served on that when he was in the jail back in June. So that case, I have an order if you wanted to see, but Judge Cataldo released him back in June from the jail after a 30-day stint. And he continued to report to probation because his probation officer told him to continue to report. So even though he was time served back in June, he did continue to report on that cause of action. So, and he's been drug screened, he said, and he's been clean on those drug screens. So that's positive and hopeful. So we would just ask that the plea agreement be accepted. And as far as the community corrections report date, if we can have a 30-day report date, thank you.
Mr. Rackins, is there anything you'd like to say on your own behalf?
No, there.
Mr. Leon?
State's asking the court to accept the plea agreement. I think Ms. Schweinsker did a good job of laying out kind of the fabric of the set of cases. Because Mr. Perkins has accepted responsibility for what he's done, including on the violation. We believe this is an appropriate recommendation and sentence. Thank you.
Thank you. And Joe, the probation one, you could go down even.
I did a form for it. I don't know if they want them to do it before or after. I can make an inquiry after court today.
Okay, so I think the new form they gave us anticipates a prior placement.
I wrote that on there as well, so.
Okay. All right, so Mr. Perkins, based upon the information provided, I will accept your plea agreement and sentence you according to the terms of the plea agreement. I will start first with cause number 2201 1905CM968. In that cause of action, the court will accept Ms. Schweinsker's representation that you were time served in that cause of action of Superior. And once the court awards you an additional 30 days credit, or I should say a total of 30 days credit, plus good time credit, then you have satisfied that 60-day sentence, and that will show that you were unsatisfactorily discharged from probation supervision. Then in cause number 2201-2505CM989, on the charge of possession of marijuana is a Class A misdemeanor. I will sentence you to 180 days at the Elkhart County Correctional Facility. I will award you credit for 2 days served plus equal good time credit. And for the remaining portion of that sentence, I will authorize alternative placement through Elkhart County Community Corrections at a level of supervision that they deem appropriate. And pursuant to your plea agreement, you agree that you are going to obtain an addictions evaluation plus any recommended follow-up treatment. I will also order that you participate in any other programming or treatments that your case manager believes will benefit you. I will order in that cause of action that you pay the mandatory court costs, which includes the $200 drug interdiction fee. No additional costs will be imposed. Consecutive to that cause of action and cause number 2201-2505CM1027, on the charge of domestic battery as a Class A misdemeanor, I will sentence you to 1 year at the Elkhart County Correctional Facility. And Ms. Schweinsker, there is no credit in that case, correct?
Correct.
There is no credit to award in that cause of action. The entire sentence is suspended on probation.
Kelly, thank you so much. Thank you. So if you highlight a message like that in Twitch, it costs money. Get a bigger cup. You need a hot tub. I know I need a hot tub. Oh, just a hot tub and wine. And I know you guys aren't going to agree with this last part, but hot tub and wine and 40 degrees outside. That would be great. That's her name.
A level of supervision deemed appropriate by the probation department. The court will order Mr. Perkins.
So I have a mental block. Every time I think of her name, I think of Caputo. And I know it's not Caputo. So I can't move on from that. I might just start calling her Caputo.
That you participate in any programming or treatment that your probation officer believes will benefit you. Do you understand that?
Yes, ma'am.
And there is not a request for a no contact order. Is that correct, Mr. Leong?
That is correct, Your Honor.
The court will decline to impose a no contact order. If there was a pretrial no contact order, it is dismissed. The court will make a domestic violence determination. Mr. Perkins, what that means for you is that you are prohibited from possessing firearms and ammunition. It means that you may also have restrictions in parenting time with minor children. Do you understand that?
Yes, ma'am.
The court will impose the mandatory court costs only, which includes the $50 domestic violence fee. And it doesn't look like we have any bonds in place, is that correct?
I did bond out, yes.
Okay, for the domestic battery charge or the possession of marijuana?
Possession.
Okay.
It was possession. Sorry about that.
I see that now, bond posted, that it might be a surety bond. Yes, that was a surety bond. The court will show that the surety bond that was posted in CM 989 is ordered released. The court will show that the appearance of the public defender's office is withdrawn on all three causes of action. Judgment of conviction is entered in CM 989 on count 1 possession of marijuana as a class A misdemeanor, and in CM 1027 on domestic battery as a class A misdemeanor. Any remaining counts are ordered dismissed. Ms. Schweitzer, other than putting a date for community corrections, is there anything else?
I don't believe so.
Mr. Finneran, is there anything else?
No, thank you, Your Honor.
All right, Mr. Perkins, I will order that you report to Elkhart County Community Corrections for an orientation on November 19th at 6 p.m. Ms. Schweitzer is writing that down on the Elkhart County Community Corrections pamphlet. The information about Elkhart County Community Corrections is contained in that pamphlet. I'm also going to send you down to the probation department before you leave so that you can sign any terms of probation or anything necessary for probation.
Okay.
Even though you are starting off with Elkhart County Community Corrections, and then you will turn over to probation, the terms of probation start right now. So that means if you violate your placement on Elkhart County Community Corrections, don't be surprised if probation also files a violation. Okay? So go down to the probation department, which is at the end of the hallway before you leave.
Okay, thank you.
Thank you.
Pierre Talley.
Thank you for wearing your best sweatshirt to work, sir. And another one. This was
This is
made.
October 20.
I got this on the 20th of October. They're wearing thick sweatshirts in Indiana on the 20th of October.
01-2504-F591, Steve Indiana versus Pierre Talley. Sir, raise your right hand. Do you swear or affirm under the penalties of perjury the testimony that you provide to this court with the truth?
Yes,
Can you tell me your full name, please?
Pierre Talley.
Thank you. The court shows that the defendant appears in person and also with attorney Chelsea Saracen. The state appears by DPA Josh Leong. And I show that we are set today for a change of plea hearing. Ms. Saracen.
Thank you, Your Honor. I had attempted to reach out to the assigned DPA again, to see if there was what the plan was or if there was going to be a potential resolution. I did not receive a response prior to today, and Mr. Talley had already paid for a train ticket to come here from Ohio, that he was not able to be reimbursed for. So I guess we're having the hearing. My thoughts was just setting it for trial in light of that. But Mr. Talley is reluctant to do that just yet. So I guess I'm asking for a continuance to see if this can be resolved prior to taking up space on the trial calendar.
Mr. Leong.
No objection to the continuance, Your Honor. I think that there's a chance, but I don't know how close the parties are in terms of getting a resolution, be it short of trial. But I think particularly because Mr. Talley's interested in seeking a resolution, we have no objection.
Is this Mr. Gerber's case?
Yes, it is.
Okay. So, Ms. Harrison, I share your perceived frustration as well as your clients. Okay, and you just need to, client just needs to know, one way or another, if there's going to be a plea tendered that is acceptable or getting on the trial calendar. Mr. Kelly, I can understand that you might have some concern about getting it on the trial calendar. That could cause the state to either revoke offers or change the offer that's not favorable to you. But at some point in time, we just need to know how to go forward with the case. So, Mr. Kelly, I will allow one additional continuance to find out if you're gonna be able to resolve this case short of trial. If not, certainly it's not a concern from the court's perspective, putting it on the trial calendar. That's something that upsets the court. Hopefully that doesn't cause any other issues for you, but for everybody's sake, especially yours, we just need to know how this case is going to get resolved. All right, Ms. Harrison, do you have a time frame in mind?
Well, like I said, Mr. Talley lives in Ohio, so that does present some challenges, with us being able to review things together. I guess I would ask, at least,
How does that present a challenge exactly? What challenge does that actually present? Because you know all the evidence that you have is electronic. You don't have paper. You can just share your screen. And if you have a video, you can just share your screen. We don't all have to sit in the living room while Dad sets up the projector anymore. You can go over everything with him with that thing you have right in your hands right now.
45 days and an attorney conference set in the next couple of weeks.
December 8th.
That would be fine.
Yes, Your Honor, that works for the state. Thank you.
The court shows on motion of the defendant and without objection by the state, this cause of action is continued to December 8, 2025 at 8:30 a.m. The court shows that the delay is chargeable to the defendant for purposes of penal force. Anything else, Ms. Harrison?
No, thank you.
Mr. Leon?
Did we want that attorney conference date?
Oh, yeah. Yeah, I'm sorry, when was that?
In the next couple of weeks, Your Honor.
Thank you, Mr. Leon, for reminding me of that. November 19th, Ms. Harrison, or sooner,
If we could have something sooner.
November 12th.
Can we do November 5th?
November 5th, please, at 1 p.m.
Thank you.
Great, thank you.
We can print for interpreter case.
Mr. Aguilar, raise your right hand to be sworn. Do you swear or affirm that you justly, truly, and impartially interpret to the clients the oaths about to be administered to them, questions that shall be asked of them, and the answers they shall give to such questions relative to the cause of another consideration before the court will apply?
I do.
Can you tell me your full name, please?
You're welcome. Adrian Aguilar.
Alman Arahu, Oliva.
This is State of Indiana versus Olman Arajo Oliva, cause number 20B01 202 F6181, 20B01 2502 F6196, 20D01 2503 CM442, and 20D01 2503 CM443. There's also a companion protective order matter, clause number 20D01 2502 P0154. Sir, raise your right hand to be sworn.
Señor, levante su mano derecha para ser colocada bajo juramento.
Do you swear or affirm
Si usted jura o
under the penalties
afirma
of perjury?
bajo las penalidades de perjurio que el testimonio que usted
Oh, hell no, sir. No, sir. We're not going to do that. We're not. The interpreter's too loud. And she talks forever. And then if we have to wait for her to be interpreted really loud forever, no. I got my I have some standards in what I show, guys. they're, they're really, really low, but they're higher than my dating choices, if that helps you guys at all. We're going to do something way different than what I normally do. Way. So I heard, I don't know, but I know I'm going to get help. I heard there was a special guest here yesterday, and it was awesome. So we're going to do Judge Middleton. Yeah, this might be the very, very, very first time I've ever done Middleton on this channel. This might be it right here.
We're back. We're going to address our small claims docket. Shannon, will you? Mr. O'Brien, I can deal with him on Wednesday morning with the arraignments. He has a $50,000 cash or surety bond in his new case. And he is not presumed to be innocent in this case because he pled guilty. He failed to appear for sentencing. So we will do Marty O'Brien with my morning arraignments on Wednesday, the 12th. I'm not going to get to him.
Sugar, no.
No,
Did I pick the wrong one, Zach?
I'll do it by Zoom.
This
That's
was
just
one
a
day ago.
summary. Give him some jail and credit for time served.
Should I get the one before it? Everybody
All right,
knows
we are now
Judge Middleton.
changed gears to small claims.
Thank you.
Because I got the criminal case, but I didn't grab the small claims case.
Should I go to the one before this one? Is that one better? I don't know. I haven't watched Middleton since I started because I don't have time to watch Judge Middleton now. This one, I'm just gonna press play.
I don't, just take the R.
Well, and fast forward if you left the bench. That's his security guard? Okay. He comes right back. I hope that beep goes on the whole time.
Everybody stay seated. All right, Elena, would you come into the proceeding? I'll give you a proper name. And it's not Elena. You're here on which case?
TM Asphalt versus Travis Blair.
All right, I'll give you a TM Asphalt. And Brenda Garn, would you join us, please? And John Reading and Christy Worrell. Ms. Garn? Ms. Garn, can you hear me?
Yes.
All right, I'm going to call this case. This is Brenda Garn versus Tiffany Schweitzer. It's a claim for $7,000, which is the current limit in small claims. They were never able to serve this lawsuit on Ms. Schweitzer, so we can't proceed. at this time?
I heard she was in Jackson.
Say that again?
I heard that she was in Jackson, Michigan.
All right, well, I'll allow 60-day continuance for attempted service.
Okay, before we jump into that crazy, Josh sent me
ensure we can properly sustain and enhance.
Josh sent me another crazy yesterday that was pretty good, and it's only a few minutes long. It's fast. It's thorough, but it's fast. So this is going to be our foreplay for Judge Middleton. If we're going to do Judge Middleton, we should do it right. And we should do it when we're all in the mood and we're all ready. This guy's going to get us there right now, better than coffee or anything else. Are you ready? Too late. I press play. All right, and
I come before you this evening not as an enemy of this township, but as a man whose constitutional rights, both federal and state level, have been violated repeatedly by those sworn to uphold them. I stand here as a citizen, a journalist, and a father, appealing not for privilege, but for protection under the very laws that govern us all. Since July 27th of 2025, I've been arrested 3 separate times, each incident a continuation of an escalating pattern of retaliation and abuse of authority. Not for crimes, but for courage, for exercising rights guaranteed to every American under the Constitution. On July 27th, I lawfully entered the North Huntington Police Department to seek answers for this community about stolen vehicles, methamphetamine trafficking, and assaults against the elderly. Instead of transparency, I was met with hostility. Instead of dialogue, I was met with handcuffs. I was arrested without warrant, without probable cause, without an affidavit, and without being brought before a judge. My phones and cameras were seized. No warrant, no paperwork, no Miranda warning. I was kicked out of the front door with nothing documenting my detention. Only the next day was an affidavit written, and only on July 29th were charges filed. Those are clear violations of the Fourth Amendment and Article 1, Section 8 of the Pennsylvania Constitution. Grestine v. Paul requires prompt judicial review of any detention. That was not law enforcement, it was lawless enforcement. The second wave of charges came on August 13th, 2025. After my July 16th public address where I spoke for 6 minutes instead of 5, I never refused to leave. I simply refused to quit speaking until I got my grievance on the record, as I have a constitutional right to do under the First Amendment and Article 1, Section 7 of the Pennsylvania Constitution. Yet the township's investigation into the meeting didn't begin until July 29th, the very same day the first charges were filed. That's retaliation disguised as law. In Fields v. City of Philadelphia, the court held that citizens have a clearly established right to record and criticize public officials performing their duties. And in City of Houston v. Hill, the Supreme Court ruled the First Amendment protects a significant amount of verbal criticism and challenge directed at police officers. When government punishes its citizens for speech, it ceases to be a republic and starts to slowly become a regime. My third arrest came on October 3rd, 2025, and this time it was brought forward by the Pennsylvania State Police. The charge alleged that I endangered a public safety official under 18 PA Criminal Statute subsection 2719A2, all because of a Facebook post from July 1st, a post containing publicly available photos the officer himself had uploaded to his unrestricted account. An account that remains unrestricted to this day with the same photos in question. The post included a call to action for my fellow citizens if they too did not condone the officer's conduct. I said they should exercise their right to give him the middle finger should they see him in public. That gesture and my invitation to engage in it are clearly protected speech under the First Amendment. In Cohen v. California, the Supreme Court held that a citizen wearing a jacket reading, "Fuck the draft," this is from a Supreme Court case, guys, okay, "Fuck the draft," was engaging in protected expression. And Duran v. Douglas, the court ruled that giving the middle finger to a police officer is a form of expression. Ron Zona, lifelong police officer, right? That's not a threat, that's dissent, and dissent is the heartbeat of democracy. Charging me under 2719 for symbolic protected speech is not only unconstitutional, it's a perversion of justice and a weaponization of state power designed to intimidate both me and anyone who might dare to speak out. To make matters even more alarming, the Pennsylvania Attorney General's office is now prosecuting me on all 3 of these charges, escalating the situation in what can only be described as a desperate attempt to keep you, the public, from hearing what I have to say. Instead of addressing misconduct within this township, they are weaponizing the full weight of the Commonwealth to suppress a journalist, a citizen, and a father who refuses to be silent. That's not justice, it's persecution. Article 6 of the United States Constitution, the Supremacy Clause, states, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land." No township ordinance, no police policy, and no commissioner silence may override it. The 5th and 14th Amendments in Article 1, Section 9 of the Pennsylvania Constitution guarantee that no person shall be deprived of life, liberty, or property without due process of the law. Yet I was detained without cause, my property seized without warrant, and my speech criminalized without justification. This is a total and complete disregard for the Constitution, and it is unconscionable. Therefore, before this board and before the people, I demand that all charges against me be withdrawn immediately, that all property seized on July 27th be returned without delay, that formal written apologies be issued by the police department and this board, that an independent outside agency be referred to the conduct and a full investigation into the conduct of the North Huntington Police Department, the behavior of the township officials, and the township's financial and ethical practices.
Nick, your time's up, but I'll give you a little bit of time
I'm
to wrap up.
very close to
Yep,
the end,
you
and
can
I
wrap up.
appreciate
Yep.
that, Zach. And I also demand that this statement be publicly discussed with motions made, seconds called, and votes taken. The bare minimum you can do is acknowledge the people who come here to speak. You do not get to pick and choose who deserves an answer. Every citizen who stands at this podium deserves a response. You took an oath to uphold the Constitution. That oath means something. Silence in the face of abuse is complicity. When a government punishes speech, seizes property without cause, and manipulates the law to silence critics, it's not democracy, it's tyranny. And when citizens refuse to bow to it, that's America. So again, I say the weaponization of power against the people ends now. I demand accountability, I demand transparency, and I demand the return of my rights. The era of silence ends here. And in closing, fuck you, Ron Zona.
Any other residents would like to speak tonight that didn't get a chance to sign the book at the podium?
I know you're gonna be shocked, but they didn't respond to him. They didn't give him his stuff back. They didn't have emotion. There was no emotion for him. None, zero, zip, zilch. It was like he wasn't even there. And now we're ready for Middleton.
So I'm sorry I had to wait an hour for that, but actually we're 28 minutes behind, all things considered. That isn't terrible. So with no hearing today, we can't do a default unless she got served with the action. And so that matter was continued for up to 60 days to attempt to get service. So Ms. Garn, you're good to go. If you get further information about where she is in Jackson, we can attempt that.
Okay.
All right, good luck. I'm gonna remove the waiting room. All right, next up is TM Asphalt and Sealing of Schoolcraft versus Travis Blair. You gentlemen are here from TM Asphalt?
Yes, sir.
All right, would you state your names
I'm
one at a time?
I'm Brandon Bordner, owner of TM Asphalt.
I'm Terry Moyer, sales rep on this project.
How do we spell Bordner?
BORDNER. N-E-R.
And Wyeth? Terry, what's your last name?
Moyer, M-O-Y-E-R.
And you're the service rep?
Yeah, just, sales.
All right, would you both please raise your right hand? You will swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief.
Yes, sir.
Mr. Blair has not appeared.
I'm right here, sir.
Oh, he's here. I thought you were with her. All right, Mr. Blair, would you come up and have a seat?
Yes, sir.
I misunderstood. I'm sorry. That's what you get for assuming things.
So, right here, fine.
You're the defendant.
Yes, sir.
Would you please raise your right hand?
Yes, sir.
You swear or affirm any testimony you're about to give here will be
This is
true
challenging.
to the best of your knowledge and belief.
Yes, sir.
Thank you. Sorry, I didn't realize what the deal was. Miss Brown and Mr. Reading and Miss Worrell and both of you, you're all here on a small claims case. I apologize, keep blowing my nose, but small claims is a separate division of the 3B District Court. Claim is limited to $7,000 and you can sue for money damages only. You can't sue for a tort. And I'll explain that later if it becomes relevant.
Ceiling fan.
Neither party is allowed to
We need
have an
that.
attorney in small claims court. We don't strictly follow the rules of evidence or procedure. That is, I won't make you go through a bunch of foundational rigmarole to get letters and documents in, but everybody is under oath. This is important. There's no formal record being made in small claims court, and there's no appeal. Any decision made in small claims court is final. Gentlemen from TM Asphalt, you understand?
Yes, sir.
Yes.
Mr. Blair,
Yes, sir.
Miss Brown, and Mr. Reading and Miss Worrell?
Yes.
Yes,
You
Your Honor.
agree? All right, we're gonna take this one first and then we'll address yours. All right, this is a claim for $2,825.82. Let me get into the electronic file. We get a lot of these different contractors suing on non-payment of a contract. In this particular case, I got so much junk in here, I haven't had a chance to clean it out. The plaintiff claims that amount for services rendered and the amount unpaid. The total was $13,940. Defendant paid $11,114.38, and plaintiff contends $2,825.82 is due. Mr. Blair has a different view of things, and he filed an answer. Sorry, I don't have copies of these. I have to go. He says, I agree to pay something, but this is not full amount. Working on getting a code for unfixed damage. I counterclaim for $3,000 because of the damage done to my yard, harassment by Terry Mosby.
Should have been Moyer.
Moyer, for just showing up at my house, causing issues. You can't really sue for that sort of thing.
He showed up unannounced after I made a formal complaint online about their poor standard of quality, and actually admitted that they were at fault. The owner.
All right, well, you're the defendant, so
Yes, sir.
they get to go first.
No,
I'll
no,
hear
sir.
your story. You're all under oath. All right, gentlemen. Mr. Bordner, why do you believe he owes you $2,825?
I will say there has been some additions that we've had on the service
You're
charge.
gonna have to speak up. I'm having trouble hearing you here. Maybe it's because I'm elderly, but
There have been some adjustments to that. He has made an additional $200 payment, and we have had another service charge added on for the overdue nature of the bill. I currently show the overdue balance at $2,665.21.
all right. Now, Mr. Blair, your answer is a little unclear. You said I owe some and I'm willing to make payments, but on the other hand, then you counterclaim for $3,000.
Well,
So
I have a issue with the driveway itself, Your Honor. I have sinkholes developing in part of the in the driveway that extend over 35 feet long and about 25 feet wide. They were not there originally. They started off as a small little hole. They have since grown and almost runs an entire length side of my driveway, which I have pictures and video of. There's several cracks. One crack in general is over 25 feet long or 22 feet long. The cracks continue to grow as the weather continues to worsen. I have cracks down the side of the driveway, which are not relevant to what Brandon's going to say it's part of the edging, but it's not. It's actually, if you look at the driveway, it's cracking. I've got samples from where my driveway is cracking, which he assured me would never do, and it's cracking here. I also have both of them. I recorded both of them on my property where they both admit that they could have easily fixed this, but they decided not to. Brandon and Mr. and Terry said that it's an easy fix with heat and a hammer, and they never even bothered to bring either when they showed up in my house the second time. I have to get estimates, but right now, small bar park, they parked their heavy equipment along the side of my driveway, and it left 2 deep trenches, which also resulted in damaging the deck of my mower, which now I need a quote on that. They used part of my driveway. They used part of my, I had seed and I had mulch and I had some peat moss. They used that as support for the driveway. Even right in that same spot, I have a tiny sinkhole developing there. It's probably about 5 feet long. The damages overall, Your Honor, I have not been able to get an estimate. So, but I think that with everything going on, I think it's easy to say that I also filed up with a letter, different letter. I mailed them a certified letter to which Mandy signed. I mailed them a letter and they did sign it. I left the receipt signed. It's in my car. It's at the shop getting repaired. But I did get a signed copy, which was with I signed an official document stating that they are to fix this. They have not even addressed it or even acknowledged it, but they did just admit to cashing the check because the check was sent with the letter.
now, which check is that?
The $200 I just sent them. And I mean, overall, they promised good, high quality asphalt, 36A asphalt. Through my investigation and my online, some of my research and looking up different cases and everything going on, you can clearly see that they use subpar material and they substitute subpar material. And as I walk out my steps, you can see that the asphalt's pulling apart and it's just turning into nothing but stone. Hot asphalt mix is not supposed to look like it's a stone or reptilian skin. And most of my driveway looks like that. Where the sinkholes are, that's about 35 feet long. That entire section looks like it's done with poor material. The causes of the sinkhole is a result of poor base setting, quickly setting the asphalt layers where they were quick to do it. And then on top of it, some material. I'm not going to pay for subpar material.
Zach,
until I
thank
have
you
a
so
quote.
much. Thank you. Thank you.
Best case scenario, that whole section has to get tore up, just get fixed. Because they have to strip it all the way down to the base layer to fix it.
All right, if they're not here, you're here, you've got a laptop.
They're right. Oh, sorry.
Yeah, they're there, but if I'm to look at your pictures, it's gonna be hard for them to see them.
Yeah, I didn't know. I just,
All right, well, there is a way to tie into that where we could share the pictures, but I'm not sure. Let's see what you got, what you want me to see.
do you want to tie it in or I can attest, if they want to attest, they were both, in person, seeing everything.
I will bring it up here. We'll see
Yes,
if
sir.
we can
Oh, you
show.
wanted to do it, man? Sorry. Oh, this is, just want that, man?
No, I want you to come up and
Oh.
operate it. I don't want to wait your
Oh,
laptop.
sorry, man. Or sorry, Your Honor. Where would you like it at, sir?
Set it right here, right here.
Facing the screen?
Yes.
Yes, sir.
What we're gonna do is
So-
I'll probably put the camera on.
Whatever you need to do, sir.
All right, what I want to see are the pictures.
Okay, so I want to, oops. This is an email, but we'll go over that later. Asphalt. Okay, so we'll get into this, right? Gotta go back. So this is my asphalt. You can see here that this is not what high-grade asphalt is supposed to look like. You can see how the, if you want, I can pull up the original. We can zoom in if you want, Your Honor. But you can see how this is all scaling. That is poor grade asphalt. That means they're using, this is them using recycled asphalt instead of high grade asphalt, which is what's in the contract with 36A. We never agreed upon that.
All right, are you an expert in asphalt?
No, Your Honor, but if they would like to testify under oath what they used, if they can demonstrate through quality controls or anything they've done.
All right, well, they can't see your pictures and I don't know if I can get my camera over there.
I can move it closer, whatever you prefer, Your Honor.
Right now, it's not even facing the right direction. It's on. Let's see here.
I have long arms, Your Honor.
Well, they can't see that, but
whatever you need to do,
it's
sir.
on this camera right here. So let's see.
I'll bring it closer.
All right, go ahead. Okay, just show me what you want to show me.
Okay, so you got the low grade quality asphalt. I go, here's the cracking. This is just a small example of the cracking. Same cracking. You can, down in here, this is actual video, but underneath all of this, it's so brittle, it's falling apart, which is part of that example. And what's happening is the seams on the asphalt, Your Honor, are breaking apart. And then underneath here, water can get in. It's gonna basically eventually separate, and all this these sections are gonna fall apart. I mean, right now we got freezing going on. So the water's gonna get in underneath all of this asphalt, and it's gonna pop it up, eventually it's gonna destroy within a year or two, these sections are gonna be completely gone because there's no base. It's all just up like this, water can get in. And now it's just eventually when it freezes, it's gonna lift and it's gonna start cracking across the driveway. Actually, if you want, I'll turn.
No, just show me the rest of the pictures.
Here's more examples, how it's just brittle, falling apart. More uneven surfaces. Right here is one example of the sinkhole, Your Honor. That's just one section. That's after a recent rainfall.
Back up.
Yes, sir. Right here.
So what am I looking at?
This is just one of the, this is
a mud puddle on top of it?
No, this is a sinkhole. Oops. This is a sinkhole from them with, they did this entire section wrong. You can see how the sinkhole is starting to develop because of it. And that's just one section. You can see here, that entire section is nothing but a sinkhole and it runs all the way down that. And that's the result of them not doing this correctly at all. Their whole base layer is wrong.
So looks like a big puddle. So it's a low point that's full of water?
Yeah, and it's not even. And eventually what's happening now is all this is freezing and it's turning into nothing but one big ice rink. Well, this is an example of poor quality because it started out, Your Honor. If I may go back. It started off almost that size, but it started off that size over here. And now it just keeps growing. And I have more, but you can clearly see how that's just a depression right there. That's an example of poor quality. And then here, if you keep, when it goes further, you see all that? That is because they did this entire job in a hasty manner with substandard material, and they did it in a fast, because they're behind schedule. because of the rain we had throughout July and August. They were so far behind schedule. Brandon can attest to, if he wants to admit under oath, they were working from basically sun up to sundown and on Saturdays because they get caught back up. More.
All right, do you have any more pictures?
Yeah, this is the latest. You can see, look how much freezing that is. They're supposed to have measurements, but you can see all of that is all frozen because of the sinkholes and depression from poor material. So you can see, this is another video of how big this depression is. This is not what a driveway is supposed to look like. It's not supposed to sink in on itself. May I move on?
Yes.
And you can see here, again, you can see how it clearly runs all the way down and all the way over. So it's not even draining, it's just flooding. And this entire section is scaling and coming apart. Everything in here is scaling and coming apart. We don't need that. This might be. So yeah, more, this is more pictures and more video. I'll start moving my stuff. Underneath all this, Your Honor, is it's cracking, and eventually my camera angle's horrible. But underneath all of this, all the way down, there's more cracking, more cracking, more cracking, more cracking, more cracking. And I'll go on. I have an actual video of all of it. Something here. So right here, as you come out, oh, this is Terry. If you want to watch the video of Terry coming out of my house, but this is what
No,
Terry.
I just want to see the pictures of the.
So that's it. I have a video. I think I have a video on my phone, Your Honor. If you want, I can play that video showing you how long the measurement is. And I have a video of it being over at 22 feet, if you'd like to see that.
No, just.
But I will testify under oath that it is over 22 feet.
All right, thank you. You can take your.
Thank you, Your Honor. And for the record, I was unsure that this would never happen by Brandon himself when he came out that this driveway. I have more chunks that I haven't even brought.
Are they on the edges?
All over the place, Your Honor. It's not just the edges. The end of my driveway, when I was leaf blowing it, it's starting to peel up because of how poor the quality is on one side. When I was leaf blowing it, it started bringing up chunks.
All right, gentlemen, that's quite a lot to unpack. Those videos were probably very difficult for you to see. But it does appear there's substantial low points in the driveway. He showed cracking and breaking along the edges, and he claims there are chunks. What's your response?
We can go through all of this, and I have an itinerary or list of dates and times that we've talked to him. And some of these complaints we have never heard of. So to go through some of the stuff, on July 17th is when the driveway was first paved. On July 25th, we invoiced Travis for the full amount. On July 25th, he wrote.
All right, now what was the full amount?
The $13,860 was the original amount.
That was the original quote?
The original quote and the invoiced amount, yes, sir.
All right.
He wrote a check to us on that date, July 25th, for $10,000.01. On the 28th of July, we returned Travis's phone call about paying the rest of his bill. Travis was not happy. He wanted to pay the rest by credit card and was going to pay the full amount, but he was not happy about the 4% fee. So he decided not to pay the remainder on the credit card. On July 28th, later on in the day, Terry went out to look at the property due to the complaints that he presented to us during the phone call. Terry then offered to fix the driveway because they were just the edge cracking. And truly, all that does take is a short amount of time, an asphalt porch, and a little tamp to compact it. He refused and said that he was not going to let a crippled elderly man do the repairs, which is when he had the video of Terry sitting on the scooter. On July 25th, he made a Google review with that same video. Or 28th, sorry, I apologize. July 28th, he made the Google review. On July 29th, tried to leave a voicemail twice. One at 12:57. He called back at 4:03. Travis stated that he no longer was paying the bill in full because the driveway was cracking on the edges and he stated numerous times that he was not going to let an elderly man fix it. On August 4th, we received a check for $112.21. On August 5th, we received a check for $2.72. Both of these have nice little comments on them. On
Yeah,
August
it's
5th,
on live
Terry
chat.
texted Travis to try and come out to fix the cracking. We did find out it was an incorrect phone number at the time. We did try and make contact and thought it was, but that was the incorrect phone number as our mistake. On August 13th, Travis came to our office to pay the $1,000 on his account by credit card to continue paying it off. Told us numerous times he was going to take us to small claims court because he had already repaired the driveway himself using crack fillers.
So did you accept that $1,000 payment?
We have accepted, yes. Yep, and that is on the invoice as showing updated and the correct balance as well.
May I add something real quick, Your Honor, if I may, when they're done, or how?
Yeah, you can wait till they're done.
Yes, sir.
Okay.
Okay.
August 13th is when he came to pay the $1,000 on credit card. Said that he had purchased all the stuff and already fixed his own cracks on the driveway with material that he had purchased on his own with no consultation. August 15th, Tammy called to set up an appointment to look at his driveway for repairs to his satisfaction. He stated on the phone call that he was not sure going to look at it was worth it because he had already started repairing it himself with his crack filler from Amazon. We still made an appointment for Friday, August 22nd at 10 a.m. to have myself, Terry, and my business partner, Tammy Stafford, attend.
All right, just a minute.
Yes, sir.
All right, so he said he started repairing it himself using his own crack filler on 8/15. What was next? You made an appointment to go out there?
Yes, sir. And then on August 22nd at 10 a.m. is when we set up the appointment where we went to the property, knocked on his door. He asked us what we were doing there. Continued to show us where he had fixed the cracks without our consultation, and we informed him again. At that point, I no longer felt comfortable fixing the cracks. Normally, like I said, they were very easy, and I have photos of another property that the same thing happened, that we fixed it and took about 10 minutes. Client's happy as can be. You can see before and after photos showing the edge cracking. Once he puts a product on there that I don't know the product and have no knowledge of, the way to fix asphalt is to reheat it through asphalt torches, and then to use plate compactors and rollers and vibratory compactors to repair the asphalt. With him having an unknown product on there, we don't know whether that produces toxic smoke or whether it melts or any of that. And so we could not fix any of the damage that he had covered with that material at that point, and we went over that with him. As for any damage in the lawn, the original invoice and his signed copy that he says states right in there that we are not responsible for any landscaping or reinforcing the edges of the driveways. We went over that with him. He did state that there was a wet spot on the puddle. The only video of that we've gotten that we could see, because I could not see earlier when he was showing you, it was actively raining when he showed us the puddle. And according to the standards that he has printed off for us, it says that the puddle needs to be at least a half an inch dip or a half an inch in depth in order to count as a depression. And he's never provided us with a video or a measurement for depth. And on August 22nd, when we met him there, as we ended that meeting, he told us never to come back on property. And so we have followed his wishes, and we have not contacted him other than sending updated invoices, and have had no further contact or showing up on property due to his own request.
Hey,
Just a minute. I'm sorry, I don't have paper copies of these. They're all electronic. So I have to go to my screen to see. I'm looking for the clause that says what's in the contract. We propose to furnish material and labor due upon completion. All work will be completed in a workmanlike manner according to standard practices. Any alteration or deviation from the above specifications involving additional costs will be executed upon verbal or written authorization, become an extra charge over and above the cost of the estimate. All agreements contingent upon strikes, accident, delays are beyond our control. The client agrees to cover all costs arising from litigation should it become necessary. Our workers are fully covered by workman's comp. All down payments are non-refundable. New pavement is very tender for a period of months after installation. It would be very susceptible to power steering, twist, and tire indentations, especially during hot daytime hours. Caution should be taken to avoid sharp turning or turning wheels while not moving. Small objects of any weight placed on the new pavement will tend to sink into the asphalt, i.e. kickstands, ladders, and grills. Please avoid these situations. Any lawn restoration is the responsibility of the owner unless otherwise specified. Resurfacing over existing asphalt or concrete that cracks will result in reflective cracking in new surface. If gravel base is found to be insufficient, there will be additional cost to be negotiated with the owner. So he accepted the proposal on those terms. What does the clause resurfacing over existing asphalt or concrete that cracks will result in reflective cracking in the new surface? What does that mean?
So that would not apply to this situation. That's when we do overlay, typically more in parking lots where you take off the the top inch or inch and a half of a parking lot and then put a new top layer on the existing base. In this situation, Mr. Blair's driveway was done from the gravel up, so that part of the clause in the statement would not pertain.
All right, you agreed to furnish and install 6 inches of 22A gravel. Was that done?
Yes, sir.
Regrade and compact the gravel base to be paved. Was that done?
Yes, sir.
Furnish and install an average thickness of 1.5 inches of commercial base coarse asphalt and 1.5 inches of commercial service coarse asphalt. So this entire project was to be 3 inches thick.
Yes, sir.
And it says asphalt 36A. What does that mean?
36A is the designation that the asphalt plants provide for the grade of asphalt that's purchased for the day. 36A is considered an industry standard asphalt for residential driveways and produced by both Michigan Paving, Reith Riley, and Lakeland, which are the 3 main asphalt producing plants in our area.
He claims that you did not use 36A, but used recycled asphalt. What's your response to that?
I have zero control. The asphalt plants produce all asphalt in the area for all asphalt companies. When we show up, we order the surface and the tonnage that we require, and the asphalt is put into our trucks and they get tested by the state to make sure that when they say it's a 36A, they're tested periodically to make sure that the scale and size, all that matches a 36A spec.
All right, so what you purchase, who'd you purchase it from?
Reith Riley was the producer of this gentleman's driveway.
And where is that plant?
Kalamazoo, Michigan.
And what you paid for was 36A coarse asphalt?
Yes, sir.
All right. Now, the biggest thing he has, I suppose, he claims there are depressions which are causing it to have these low points which fill with water. and that would be from an inadequate base. What's your response to that?
So when paving, I mean, you are moving, low spots can be developed due to compaction and things like that. We do fix them on a regular basis. I have an infrared machine and we go behind lots of the different paving companies through different parking lots and do repairs of low spots. Industry standard does tend to hold that it has to be a water puddle that persists for longer than 24 hours at 80 degrees. And according to Mr. Blair, the tolerance that he
This morning,
you would like to follow is 1/2 inch in.
go ahead.
So, and I do not know, we've never been provided with a measurement of depth, and because we were asked to leave the property and not come back. And the only thing we've been provided was when it was actively raining. That I honestly, and I could not see the videos that he provided to you. I don't know if it's a 1/2 inch in depth, nor if it persists after 24 hours.
All right, Mr. Blair.
Okay, first, can they confirm that, Mr. Moyer, can you confirm that you called me before coming out, and what day was that?
The only thing that I can confirm to you is that I called you when we were getting ready to do the grade work. You explained to me that you had, to make sure that there would be no vehicles there, you explained to me that you had kicked your girlfriend out and that there wouldn't be a problem to come anytime. And yes, I did not call you prior to the paving dates, just be based on that and just things that I had going on, but I just went by what you said, that you would be there if they needed a vehicle, you would be there, that nobody else would be any vehicles left there. So that's all I.
And can Mr. Brandon, can you please confirm that you testified that Mr. Mosby did call me before coming out?
Mr. Moyer.
Mr. Moyer, can you please testify, what's the owner's last name, sir, Your Honor? I need him to, because he stated in his testimony that Mr. Moyer did call me before coming out because of my online complaint. He did testify that.
So we've been out to your house on several occasions, very told me verbally.
That's Mr. Borden. So what's the relevance of this?
It's the fact that I made an online complaint and it goes to a, just what I said about the harassment. And Your Honor, I have a blog standard, a blog point from TM Asphalt's own website. They actually recommend that you use a hot rubber crack filler edge to seal the cracks on the edge of a sidewalk, on the edge of a driveway. This is straight off their website. I don't know this whole heat thing, but they even recommend it. I even explained to the
all right, well, you took self-help and made some repair on it without.
That's because Mr. Moyer didn't offer any solution, Your Honor. When he came out in a scooter and a boot. And all he said was, we could just heat it and hit it back together. That was his only solution, Your Honor. Never once did he state that he would call the office and make arrangements. He came out.
Well, by the time they came out for the appointment later in August, you'd already done some self-help.
It's because they offered no solution, Your Honor. Because when Mr. Moyer left, he stated that the only solution was to do two things: heat it up and tap it back in, or I need to lay down more topsoil and help prevent it from cracking further. That was the only two solutions, and Mr. Moyer was in no ability of doing that because he was in a boot.
All right.
And he was also on a scooter. There's no way I was going to make him do that.
Well, you said he didn't even come with the tools to do it, and I don't think he was prepared to do it.
But he stated that, and then the second time they came out, Your Honor, they didn't even bring the tools either. They just showed up.
Well, they came out, they said to assess yes, just a moment, to assess the project. Yes, Mr. Bordner.
So Terry, as a sales rep, is not responsible all the time for fixing that stuff. He does carry around tools with him and he does repair some things. He was on a scooter and had a broken ankle this year. And as a sales representative, as you and even Mr. Blair has admitted when I asked him this same question, how often does a sales representative that you meet at, say, a car dealership repair your car? So Terry Moyer was not given the opportunity to repair it. And when we as a company tried to be responsible and set up the meeting to address all of these, before we got out there, he had already fixed his own way all of these crack fills. We did show up with the tools because they were in my truck, and Terry had another set of tools in his truck that we could have done the repairs for. Mr. Blair also just said that on our website, it does state that cracks should be repaired with hot pour asphalt or hot pour rubber. He, I do not believe, used hot pour rubber to his repair. And when we asked him what he used from Amazon, he described it as a cold pour caulk that he
I did
bought.
not describe it as cold pour caulk. I described it as an asphalt caulk. And it was, you said you didn't have any idea what asphalt caulk is. I can play your words if you want to hear them, your own words.
No, wait, we need to go back. You two just skipped over the whole broken ankle thing. How did he break his ankle? I need to know if Crocs were involved. Then I can roll. Then I can make a judgment here.
I apologize.
I recorded our conversation.
Use the wrong terms. Asphalt caulk is fine, but either way, it does say on our website, we recommend a hot pour rubber. And that is not what he used. So even doing his own repairs, he did not follow the recommendations that are put on our
But
website.
neither were you guys.
All right, well, stop. We're not sitting around the kitchen table. We're
Yes,
at
Your
a
Honor.
trial.
Yes.
And this is all about clear as mud. Some of the things that you're suing for, you can't sue for.
Yes, Your
You
Honor.
can't sue for anguish and pain and suffering. You also can't sue for any damage to your lawn. So,
What about my driveway where they forced their way into my garage and
You
cracked the
heard right,
driveway? I don't have a
Chunkin.
quote on that, but they did force their way into my driveway, into my garage, Your Honor, and parked their machine in there. And I still gotta get, I'm missing tools and stuff. I gotta find receipts, so I get
well, wait a
that.
minute, don't just start throwing spaghetti against the wall, see if it'll stick. Let's see what's in your counterclaim.
Jimmy, I missed your comment. It's not showing up. YouTube is messing with me today. First it was Drunken, now it's you.
I believe plaintiff owes me money because damage done to my yard. You can't sue for that.
I don't have the number. Oops, sorry, Your Honor.
Harassment by Terry Mosby for just showing up at my house, triggering my PTSD. Well, you can't sue for that either.
Damn it.
A, I
Damn
don't know
it.
if you've established it, and B, you can't sue for a tort, like infliction of emotional distress. So.
I didn't know that, Your Honor. I
Well,
apologize.
that's common. We have it in the next case also. I have it documented that they were at fault.
I have them both on the record stating, Your Honor, can Mr. Moyer please state if he was the one who sold TM Asphalt to the current owners?
Well, I don't know what.
That's
difference-
relevant because, I'm sorry, Your Honor, it's relevant because if Terry sold them this, he would be qualified to know what.
Do not interrupt the judge again, sir, or you will be held in contempt by this whole chat.
Damages are. He's not just a sales rep, he used to own the company.
All right, fair enough, but I'm looking at your counterclaim. $3,000 because they damaged my yard. The contract says that's on you. Harassment by Terry Mosby, that you can't sue for that. So that's what's in your counterclaim.
Yes, I understand, Your Honor.
All right, so then let's look at their claim. The quote was for $13,940.20.
13,860 was the original invoice.
That's correct.
Yes, then the actual invoice submitted on 7/25 had a credit card fee and some other stuff, so 13,940 minus 11,1438. Now, what's been paid?
Yo, I agree though. I agree with that one. You should be able to sue for PTSD when people you don't want to come to your house come to your house. if we could just sue for PTSD in those situations, people would stop coming to houses so much.
Paid since 11/14/38.
Since
$8,000
11,
each
he has
time.
sent us a $200 check, which brought the balance that he owes, excuse me, to $2,625.82. And then due to the timing of everything, we had a finance charge added on for the overdue balance of $39.39, bringing the total amount balance due according to our records to $2,665.21.
All right, and that's close to what you pled. Now, he does seem to have some legitimate issues here. I can't tell about the sinkholes. The quality of the video wasn't really good enough for me to see it, but it's breaking up along the edges. And your claim is he didn't give you a chance to fix it. And then he used a self-remedy.
Both of those are valid if that in fact happened. What is that stuff you send people with a cold? Air. I think it starts with air. And it's like 60 billion vitamin C or whatever. Anyway, we should all chip in like 25 cents, all of us, and send poor Middleton a box of whatever that is. It's something. I know it's something. I just don't know what it's. I can't remember what it's called. But airborne. You just all send Judge Middleton a box of airborne, because I just do not like it when he is sick. It just hurts my heart. I want him to feel better right now. Or at least, Zach, you're in Florida. Send him a frickin' orange, please. It's October. You know how hard oranges are in Michigan in October. We get these yellow things. And I don't know if yellow oranges or they're chemically orange. They're either yellow or chemically orange, and I don't know if they have any vitamin C in them at all. Someone needs to send Judge Middleton a box of tissues, the puffs plus with lotion, and airborne, and a freaking orange. Please. I feel he's breaking my heart. Zicam, that'll work. Vicks Vapor Rub. Maybe he should just go home. We will finish this case for him. We got this. We are pros.
The project was put in on the 25th.
So we go
and by
clients that they
within 2 weeks, he was already doing stuff to it.
It's said with landscaping that they have to shore up the edge anytime an asphalt, and we go over this with the client, is left with a full 3 to
You
plus
guys never did though.
of the asphalt. Gravity can pull away. It's why we put that landscaping has to be done, which we go
Which
over.
isn't also in the contract.
All right, again, only one person can talk at a time.
Sorry, Your Honor.
We also, I mean, I have video evidence. I did this a week ago to a client that we paved that had the exact same situation. I don't know how to show you photos over Zoom.
Yeah.
It shows the exact same edge cracking, and I don't know if you can bring these around, at least attempt. If you can't, please let me know. I completely understand. But you can see like that edge crack.
Yes.
Right? And then as we zoom out, you can see the same crack along the edge there that shows the back of the car. All that we do is we take an asphalt torch and a tamp, and we heat the asphalt back up to close to the 200 to 300 degree temperature that it is when we put it down.
T, I am so sorry, T. I feel so bad right now. I had no idea that inmate was going to do that on camera, and we had to watch it. Do you know that maybe 5% of us saw that actually happen? The rest were blissfully in chat. That's why when you watch my videos, my live streams, not my videos, you should only look at chat, because it's looking at the stream can actually cause PTSD. T, I'm so sorry.
we hit it with the tamp and it smooths everything back out. And I don't know how well you can see that, but that entire edge, the crack is gone and the entire
Yes, I can see it.
loose asphalt is corrected. That repair and that 10 feet of repairs took me maybe 15 to 20 minutes. And I talked to the homeowner and explained the same thing, that with a couple bags of topsoil, he probably never needs to call me again. If it did happen again, to call me, I'd come back out and do the same thing to address the situation. And it truly, we do that, I would say, out of all the driveways we do a year, there probably is somewhere between 2 and say 10, I don't know what the average is, but somewhere in that range every year that we get these calls and we show up with a little tamp and a torch and we heat it up and we fix it. And I would say if on the worst side you do 10 a year, I don't know, I think maybe one I've got called back to a second time.
All right. Mr. Blair, anything else you wish to say?
I would like to know why Terry just showed up if the owner himself is the one going out repairing it. Why is Terry coming out if he's the one fixing them? If it's that simple, I'm not understanding that. Because I have them on recording that when they did this, they knew that this would happen. And
Well, what's the difference? If the service manager comes out to look at it,
when Terry left, there was no mention of anyone coming back out or future calling or contacting. I was basically under the impression I was on my own. And then the last time I made any online complaint, I got follow-up calls asking me to change my review. That's what I thought they were doing. I've never had anyone show up at my house unannounced after I make an online complaint, but here we are. That's what Terry did.
well, maybe he came out to see what the concern was. So,
But
Mr.
the
Moyer, he
owner
says,
testified that he's not qualified, though, Your Honor. If the owner testified he's not qualified, why is he the one coming out?
well, he's qualified to look at it.
That's not his testimony, though.
Well, Mr. Moyer, did you come out and look at it?
Yes, I did, sir. And at that time, there was when we put the second layer of asphalt on, we pulled the top layer over the bottom layer, and that's what had cracked, which was very minimal amount, would have taken very little to fix it. And then there was the mention of the garage door being opened and about us having Hispanics working for us and different things like that, but that was it. And then that was kind of the end right there, is that I would get it fixed. It was, wasn't going to do it that night that when I come, but I would have fixed it. And then, we in review and stuff, we just didn't feel comfortable going back out there until we all went out. We would have fixed it that day.
So you all went out there that day, which was the 25th or something. Did you have the tools and equipment with you to repair it on that day?
Yes, sir. We both carry around those tools and equipment in our trucks pretty much the entire summer because, well, I do those repairs I do all the maintenance for Michigan Paving, Lakeland, Reith Riley, and I get phone calls on a darn near daily basis to go repair things like this for them.
All right, so you said at some point he told you to leave and not come back?
Yes, sir. And we got in our cars after he had videotaped us and he said, "Don't come back. I don't want you on my property." And that's after he had already done his own self-help repairs and those things. And we have not, other than sending updated invoices with the updated totals, we haven't made any contact with Mr. Miller since then.
May I add context to when they did come out, Your Honor, they did nothing but circle around and refuse to even acknowledge. I did point out the sinkholes and they completely glossed over it and didn't even address it. From what I'm gathering, they're gonna have to rip that whole section up just to fix it if they have to. I did point out the cracking. They had no tools with them. If they did, yeah, it was in the truck. But I mean, if I was gonna go fix something, all they had to do, if it was that long and if they were willing to, I would have helped them. I even stated that to them. But they didn't bring any tools. They did nothing but make excuses. They walked around and were nothing but condescending, rude, and disrespectful. I got agitated, went in, grabbed my phone, started recording them, and they kept lying to me. I mean, it's just at some point in time, if they were going to fix it, why didn't they say, "Hey, you know what I'm going to do"?
Amy remembers the members only video. Sir, circling around causes PTSD on this channel, so you just need to stop. You're guilty.
I got stuff in my car. Let's fix it. And they didn't even do that, Your Honor. So they had the tools. Why didn't they bring it out and say, hey, show me where the cracks are, we'll get it done?
There was an.
They couldn't even do that. The first 5 minutes was just me arguing with them, and all they did was making excuses about it. And at one point, before the crack was even about 20 foot long. I don't know. And I said, I was on my own. I didn't know what to do. And I'm asking them. I even followed up with a professional letter saying, hey, you guys need to fix this because I don't feel comfortable. I mean, I can read you an online review where they broke into people's houses, and that's not normal.
What was the date of your letter?
Oh, the formal date, I don't have it in front of me, Your Honor, but I did send it out, and they did receive it. I believe it was.
We have this one second. The
And
formal
I know they did sign it because they did get the check. So they had the letter.
All right, well.
And I did state the depressions, and they were showing all this, Your Honor. They glossed over it. And every time I'd show them something, they would make an excuse. So I don't know what they were planning on doing when they came out there, but they just kept. I can play the whole video if you want to hear them. Just.
Maiko, I hope you're feeling okay today.
And I even tested the asphalt, that the stuff I applied. It had no issue. It's standard asphalt sealant. It's the same stuff that they would use. Or similar. I mean, if they're worried about toxicity, which they never even said, I could have shown them. I had a tube in the garage. They never even asked. I assumed you would know what the stuff is because their company is TM Asphalt and Sealant. I assumed they would know this stuff, but they just, when I told them what I'd done, they didn't ask, hey, can you show me? Can you please? No, they didn't. They also assured me the driveway when it cracked, and here it is right here, examples that it's still cracking. I got chunks like this breaking up still, Your Honor. And they assured me if I go home right now, I can pull a chunk out about that big in one spot. And what's going to happen underneath it is water's going to freeze, and the whole thing's done. By the end of this winter, that driveway is going to start having major issues. And I think that when they were behind schedule, they used subpar material. They rushed the job. I mean, they literally broke into my garage to park their machine to cool it down. I mean, I didn't even give them permission. They showed up 2 times.
All right, let's stop.
Yes, sir.
Do you think you're part of the problem? You're
No,
so angry. If I just sit there like this, you would rant for 45 minutes. I've got another lady waiting for hear her case.
Yes, sir.
You're so angry, there's nothing that they could do to make you happy.
I tried.
Then you stop. This is my turn to talk. Then
Yes,
you
sir.
went out there, you couldn't wait within 20 days of the time they put the substance down. You're out there putting around, doing something without any professional advice because you were upset about it. We don't know about these sinkholes yet because we can't tell. They came out, they talked to you, they offered to make the repairs, and you kicked them off your property.
They did not offer, Your Honor.
Well, that was their testimony.
I can play a video
Maria,
if you want to hear them.
kind.
I have a whole video if
Thank
you want to hear
Maria.
it.
I don't have time to hear it. So then you countersue them for things you can't sue for. PTSD and lawn damage. And the contract covers lawn damage. I agree, the edges look crappy on there. But you were puttering around out there with something without their blessing within 20 days of the time that they did it. They're a professional company that's been around here for years and years. And this was an expensive job. $13,000 isn't pocket change. And of course they're busy. They're busy every summer. So I don't take it as a criticism. They work from sundown to sunset. It just shows they work hard. So you have some idea that they gave you inferior materials and they rushed your job based on just your opinion about it. And then you're so mad at them that there wasn't anything they could do that was going to make it right. Then you kicked them off your property. And there's a contract. You're suing on breach of the contract, which controls. They gave you a price They told you how much it was gonna cost. They adheres pretty darn closely to the original quote. And according to their testimony, installed it according to standard practice. I would have liked to have given you something in your counterclaim to maybe level this out, but the counterclaim doesn't contain anything that I can award damages for.
Understood, Your Honor.
The amount due is $2,655.31. Plus $86.25 in costs. Is a total of $2,741.56. You would offer to make monthly installment payments in your answer. But that's not gonna get it at $50 a month.
Whatever the court decides, Your Honor, I would just like to reiterate that the initial contact with Terry, there was no mentioning of fixing the driveway other than him doing it himself. No mentioning of any future contact from the company to fix it. I just want to reiterate that.
All right,
which is why I repaired it myself, Your Honor. Because I was under the
Again,
impression that
we're
they were not going to fix
We're
it.
under a very short time frame.
Then Mr. Mosby would have said, or Mr. Moore would have said, I'll be back, we'll come back Monday. I would have never had an issue. They would have had a check after they fixed it. I could write a check today, but they demonstrated that they have no problem breaking into my property, and they showed up 3 times unannounced. That's why I don't want them back on my property, Your Honor.
All right, fair enough. One claim, you claim they didn't do it. The other company claims they weren't supposed to be there. By 8:15, or 8:13, you paid them $1,000. All right, that's my ruling. You're gonna pay this at least $200 per month.
Yes, Your Honor.
Starting December 1st.
Do I get instruction from the court, or do I pay directly
You
to
pay
them?
it
or you?
directly to TM Asphalt.
Yes, sir. I will be.
You could pay it sooner if you want to just get it over with.
Well, I plan on it, Your Honor. I mean, I have more detail once I get more. I mean, I'm gonna file with Laura and a whole bunch of other things about this in the future, so.
All right, that's up to you, but I would have tried to level it out, but as I said, there was nothing in the counterclaim I could award damages for. All right, if you go out to the counter, they'll give you a copy of this.
Yes, sir.
He owes you $2,741.56. Lesson learned here, I guess, has to do with customer service. In this day and age, people post opinions which can damage your reputation, whether it's deserved or not. I had a lady today who has mental illness problems that said on the record all kinds of things that I did, which I didn't. And you got an hour's worth of a trial on YouTube that people are gonna have an opinion about.
I'm 100% disabled veteran, Your Honor. That's why I put that in there.
Well, thank you for your service. What service were you in?
Army, sir. Out of Fort Drum, and then I did a year at Bob Fenty, Afghanistan, RC East, and then another year on a contract.
That's rough duty. Today is the 250th anniversary of the United States Marine Corps, which an
Yes,
Army
sir.
guy might only tangentially appreciate. All right, you go out to the counter, the clerk will give you a copy of this.
Straight out the same door, Your Honor?
That's right over there.
Yes, sir. Thank you, Your Honor.
Thank you, sir. Thank you for your
Thank you.
service.
What's that, sir?
Room 107.
107. Do you need anything with the bag? Everything good, sir?
You're good to go. All right, gentlemen, thank you.
All right, ladies and gentlemen, thank you. Thank you for coming out. I appreciate it. I really do. I'm glad we took a little break for Middleton today. I'm going out tonight with with my kids and the new person in the house. So tomorrow we are most likely going to do a YouTube judge again, but I don't know who. There's so many to choose from, and I don't know what, and I don't even know if it'll be good. But at least we'll be on tomorrow. I hope that you guys have a great night, and I will set up OJ and see some of you there, and I'll see the rest of you tomorrow. Thanks, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.